imagine this for a second. A child, born to parents who, for all they knew, had a perfectly valid marriage. But because of some legal technicality, maybe it was a bigamous union they weren't aware of, that marriage is declared void.
And for years, the law did something, well, something strange. It said, yes, the child is innocent, the child is legitimate. That's Section 16 of the Hindu Marriage Act.
But then the father dies. And that same child, who was just declared legitimate, is suddenly told they can't inherit from the grand ancestral family property.
Exactly. They were treated like second-class citizens, legitimate in name, but cut off from the family estate. It was this huge, high-stakes human problem.
Which brings us to the landmark 2023 ruling, Revanasiddappa versus Mallikarjun. This feels like more than just a property dispute.
Oh, absolutely. It was about dignity. You had a 3-judge bench, led by Chief Justice Chandrachud, basically stepping in and saying, wait a minute, ancient law has to align with our Constitution, with, the principle of equality.
Okay, so for this deep dive, our mission is to untangle that legal knot. On one side, you have the law saying these kids are legitimate.
Section 16 of the HMA, yes.
And on the other, you have the Hindu Succession Act, with its ancient Midikshara rules about who gets ancestral property. And the two just weren't talking to each other.
They were in direct conflict. And for a long time, the courts kept a really hard line. I mean, you look at cases like Ginny Cuden back in 2003.
What did they say?
The ruling was blunt. Children from void marriages had zero right to the ancestral estate. They could only inherit what their parents earned or bought themselves, their self-acquired property, not the family land passed down for generations.
And the reason for that, the justification, it all comes down to this one very technical legal term, coparcenary.
That's the whole game right there.
So explain that. What is a coparcenary, and why wasn't being legitimate enough to become one?
A coparcenary is, to put it simply, a member of the joint family club who gets a right to the ancestral property just by being born into that family. It's an automatic right.
It's not something that's given to you. It's something you have from birth.
Precisely. So the argument from the rest of the family, the uncles, the cousins, the collaterals, was, look, our shares were fixed the day we were born. If you suddenly make this child a coparcenary, you're shrinking our shares.
You're taking away our vested ancestral rights.
Exactly. And that's the tension the Supreme Court had to resolve. How do you give the child their rights and their dignity without, blowing up the entire structure of the joint family's property rights?
This is where the judgment gets, I think, really creative. The court pulls off this brilliant legal balancing act. What was the first thing they clarified?
They made two things crystal clear. One, these children are legitimate for inheritance, full stop. But two, and this is the crucial part, they are not coparceners by birth. They don't get automatic entry into that club.
So if they're not in the club, how do they get a piece of the pie? How does that work?
They used a tool, a legal fiction, called Notional Partition. It's actually found in Section 6 of the Hindu Succession Act. This was the masterstroke.
Notional partition sounds like something out of a sci-fi movie. Break it down for us.
It's actually quite elegant. Think of it like a freeze frame. The court says, let's press pause at the exact moment just before the father died.
Okay.
In that frozen moment, we pretend a partition of the family property happened. We ask, if the father had demanded his share right then, what would it have been? We calculate that specific slice.
So you're creating this imaginary slice of the pie that is designated as the father's share, even though a real partition never happened.
That's it. And once you've mathematically defined that share, it stops being the sort of undefined ancestral property. It becomes the father's own specific inheritable property.
Ah. And because the law says these children can inherit their parents' property.
Now there is a parent's property for them to inherit from. The notional partition carves it out without touching the shares that belong to the uncles and cousins.
That is incredibly clever. So the result is that these children can now inherit from ancestral property, but their claim is strictly limited to that one slice.
It's a powerful and neat solution. It overrules those harsh precedents and secures the child's rights.
So what's the big takeaway for anyone listening? For just a general audience?
The stigma is gone. Inheritance is secured, but, and this is big but, you have to remember the limit. The child can't sue their uncle for a share of the whole estate. Their claim is only against what their parents' share would have been.
And for the legal professionals tuning in, what's the key procedural point?
It's that these children inherit through succession, like through a will or intestate rules, not by survivorship, which is the special way coparceners inherit. So your first step in any of these cases is always the same. Apply that notional partition. Calculate the parents' share first. Everything else flows from that. This whole judgment is just a masterclass, really, in using legal tools to balance ancient traditions with modern constitutional values.
It is. They protected the innocent child without completely demolishing the joint family system. Which leaves us with a final thought for you to chew on. The court found this middle ground, this elegant fiction. But should they have gone further? Should these children have been granted full co-parcener status from the get-go? Or was this limited, calculated share the only truly equitable way forward?